Hey guys, just want to talk for a little bit tonight. I've got some questions here that you guys asked. I'm going to try to answer some of them, and we'll go from there. So I know it's late, and thank you guys for joining us. But let's go over these questions. So today we served on the state of Kentucky. So we've got the 39th state now and joined 39th state. We didn't get West Virginia. Unfortunately, we didn't have an appian. The appian was unavailable. Don't know what happened. Haven't been back in touch with her to find out what happened, but we did not get to stay West Virginia. So we're gonna have to circle back for that sometime here in the future. We might need to find another appian. So if you guys know someone or you are someone who has been charged with or convicted of a crime by the state of West Virginia, please get in touch with me, and we'll move on from there. So we're getting ready to head up north. We're in Washington D.C. at the moment, and tomorrow I need to get some more suits. So we're gonna go out, grab some of those, and then we're gonna head north. Right? We got Maine, Vermont, New Hampshire that we need to get served up. So we're gonna be doing that early next week. Hopefully Monday, Tuesday, we'll get those states done, and then we're gonna be heading back down south. It sounds like probably Arkansas area, and we got a next plan that we're gonna be doing. So we talked about that a little bit last night, what the next steps are, but we aren't gonna talk about that necessarily tonight. So if you guys know someone or you are someone that was charged with or convicted of a crime in the states of Vermont, New Hampshire, or Maine, please get in touch with me. All right. And I want to make sure we got appians. I don't want any delays on this one. So if you guys have been charged with convicted of a crime, then get in touch with me so we can get those affidavits, make sure that we are on time and we're not going to have any more slips. I certainly don't want to go to a state and then wait for someone to show up. So we don't want to do that. So we do need appians for those 3 states. I also need Maryland, but we're not going to be doing Maryland right now. We might be doing Maryland on the way back, but we don't have Maryland quite yet. And then that only leaves us left at that point in time a pickup in West Virginia, and then we have North Dakota, South Dakota, Montana, and Nevada, and that will pick up all the lower 48. All right, so we're really, really close right now. So guys, the reason why I'm doing this is because we got to keep pushing forward. I know that you guys have seen a notice that went around from the Department of Justice, where the Department of Justice is stating that the judges are not judges; they're acting unconstitutionally, and that they're no longer going to protect them. Guys, there's a number of issues with that, right? So, first off, if we have knowledge, or they have knowledge that these judges are all acting criminally, they're all unconstitutional because they're under a different branch, not following Constitution, then why is it that you still have your prosecuting attorneys there in the courthouses today, prosecuting people by way of information or holding someone over without lawful authority to do so? If the judges are unconstitutional, it would seem to me that it's not business as normal. It would seem to me that we probably shouldn't continue to send the prosecutors in to continue to, prosecute people, because everything that you do now is going to be unconstitutional, because you already told us that you're aware that they're all unconstitutional. And if the judge is unconstitutional, then you know what? That means that everything that they've done is unconstitutional. So it seems to me like we've got an awful lot to do in an opposite direction than the one that we're actually heading in. And that's why I say, guys, that we gotta look at words and actions, right? Those 2 things have to align. If they don't, you're a liar. I've been pushing this and telling you guys this for quite some time, that your words and your actions have to align. If they don't, you are a liar. So again, you guys, I don't have a problem with who gets elected, no problem whatsoever. But what I do have a problem with is that it is someone that's not being completely forthright and honest. And if we say that we're going to take the Constitution, put it back at the foundation, and that's what we're going to do, then I don't think that coming into office, signing an executive order that's expanding the private prison contract is heading in a constitutional direction. That's not the way that we need to be going. Because if we've been doing things unconstitutionally, and if DOJ puts out a memo saying that we are aware that these judges are all unconstitutional, then everything they've done has been unconstitutional. So you can't continue to go into the courthouses, continue to prosecute by any measure, because that judge, you already have stated in a memo that that they're not lawful, they're not constitutional. So it's not really a matter of we're not going to protect you anymore. It's a matter of everything you've done is not lawful, because we have just informed the whole public that we know that you're not constitutional. So there's some work that needs to be done, but it needs to be done in a different direction. and I want to see that work done. So we're going to push forward. We're not going to stop. We're going to push forward. Minnesota's been served. We served the state of Minnesota on behalf of the Sheik family. Do I need? No, we've already served Iowa as well. Iowa's been served. That was on behalf of the Bauer family. On behalf of the Bauer family. Florida's been served. That was on behalf of the Gretchen. Can't think of her last name. On behalf of her family. So the old number. There is no old number, and if anybody's telling you that you have to pay, you're calling the wrong number. So anybody that you're calling and is saying that you need to pay, you're actually going to one of these people that are stealing from you. And it has nothing to do with me or the church. So if you're being told that you need to pay to speak to me, well, I'm sorry, but you're not going to be. So thank you very much. You might need to get a different number. Colorado's been served. We served on behalf of the Bent family. Right. Every state's been served except for North Dakota, South Dakota, Montana, Nevada, Maryland, and the states up on the top. Maine, Vermont, New Hampshire. And then, of course, the Alaska and Hawaii. That the lower 48, we're down to like 3, 4. We're down to 7 left on the lower 48. Next week, we're going to have 3 of the 7 done. And then that will just leave us with having to head back out west and getting those finished, right? Now, guys, what are we doing here? Well, what we're doing is we're providing notice to the highest executive judicial officer, right? Notice that crimes are being committed by their agents. And once you notify a public official of crimes being committed by their agents, they have a duty to take action and correct those acts. And if they don't, then that means that they're sanctioning and permitting those acts to continue, which means that they are now implicated in it. You know, the way that a criminal conspiracy works is that if I have knowledge of a crime being committed or about to be committed and I don't do anything about it, right, willfully or negligently, I might as well be the very person pulling the trigger because I'm allowing it to occur. So, you know, when we tell government officials that their agents are committing crimes and we outline the criminal acts and they have been provided notice, it doesn't matter what the notice form is, right? The law doesn't state that we have to do it through a court order. The law doesn't state that it has to be, you know, registered mail. The law states that we have to make you aware. And when you provide the notice of criminal affidavit, that is making them aware. It doesn't matter if they don't read it or not because we've served it, right? So notice to agent is notice to principal, notice to principal is notice to agent. So as we notify, for instance, the Assistant Attorney General for the state of Ohio, then that means we've notified their principal, the Attorney General. And that Assistant Attorney General also has the duty and responsibility to do something about it because the agents that works with him, you know, that they're committing crime. So the laws of criminal conspiracy as it pertains to the laws of criminal conspiracy is any person who, having knowledge of any of the wrongs conspire to be done, and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined as defendants in the action. When you provide notice to the Assistant Attorney General, and you have given him a certificate of service to providing direction on what he must do with it, which is provide to your principal, provide it to the Attorney General. Whether or not he does or doesn't is irrelevant. What's relevant is you have directed him on the correct course of action. You see, the only way that you can mitigate your culpability in a criminal conspiracy once you've been made aware is there's 2 options. One is you notify the authorities of the crimes. As an Assistant Attorney General, your job would be to notify your boss. That would be the authorities of the crimes. If you're the Attorney General or the top law enforcement officer, then your duty would be to the second one, which is to notify your co-conspirators of your intention to no longer participate. Meaning that Attorney General is now in a conspiracy by and between his agents who are breaking the law. And if he doesn't notify his co-conspirators, he's no longer going to do it by saying, you must obey the law, then he's now implicated in it, and he's sanctioning, permitting it to continue. So what happens then is that notice to agent is notice to principal, but notice to principal is notice to agent. So when we notify the Attorney General, then all of his agents are all notified, right? We don't got to go around and serve all the prosecutors or all the attorneys with notices that they're committing crimes because that was his job. We went to him and told him about it, and he chose to do nothing about it, which means that he is sanctioning it. He's permitting it to continue. And now he's implicated in it and can be named as a defendant in the action. So at that point in time, we have a massive number of recusals, automatic recusals. Right now, as of this moment, there are 39 state attorney generals that cannot represent the people on these issues, right? Can't do it because they're opposing party now. And their failure to take action means that they are part of the respondents that we're going to be bringing. When it comes time to actually argue this at the Supreme Court, there's not going to be a single attorney general in the country that will be able to represent the people. Therefore, who is going to be able to? Me, a private attorney general, right? We're getting an automatic recusal because every one of these bar attorneys are all working for the attorney general, and every single one of them is continuing to engage every single day in criminal acts that they're well aware of, and they're choosing to just do nothing about it. The Constitution is not complicated. It's 4 pages. Those are their obligations. They promised to do it. They swore that they would do it. And as a result of failing to do it, they're guilty of a crime. And they've already implicitly been punished in the form of perjury. They're guilty. And they've already said that they're willing to accept guilt should they fail to fulfill the promise. So we're going around the country and we're making sure that we provide the notice. And once we do, then we're giving them an opportunity to be able to correct that action, those behaviors. But what you also have to understand is that today it was business as normal in these courthouses, right? Business as normal. The prosecutors came in, attorneys came in, they still arrested people by information, they still prosecuted people by information, and they still sent people to prison by information. And information may not be used to send a person to prison, ever. Information may not be used to arrest a person for a felony, ever. And information may not be used to hold a person over, because that would be against the Constitution. So what has happened in this particular case is that sometime in the past, the highest court in the land, the United States Supreme Court, they decided that they knew better how to govern the people than the people knew how to govern themselves. And so then they made a ruling called Hurtado versus California. And in that ruling, they said, California, you don't have to do what the Constitution requires you to do. And in doing so, what happened then was they removed the Constitution's Clause 1 of Amendment 5, which requires the indictment by a grand jury, and they put into place their own ruling. And then they called it law, case law. And they said we can create law, even though, of course, judges cannot legislate from the bench. That would be a separation of powers. They decided they can create law. And thus overstepping their separation of powers, legislating from the bench and doing something that they're not delegated with the authority to do. The people did not delegate the right to create law to the judicial branch or the executive branch. Didn't do it. And so when the judicial branch does create law, well, that's unconstitutional, guys. It's unconstitutional because we didn't give them authority to create law. All legislative powers vested in Congress of the United States, consisting of Senate and House of Representatives. That's Clause 1, Article 1 of the United States Constitution. All power to deal with law, make, amend, create, destroy, is vested in the Congress of the United States, and only Congress. No other branch has any legislative power whatsoever. So when the Supreme Court of the United States does create a ruling and erroneously calls it law, thus creating an unconstitutional provision by removing what they're constitutionally obligated to protect, defend, and preserve, well, now they have created something, again, that's unconstitutional. And according to Norton versus Shelby County, United States Supreme Court, that when any unconstitutional law is not unconstitutional from the moment that it's deemed such, but rather created, as though it was never created at all. It creates no office, provides no protection, grants no authority, no court is bound to obey it or enforce it, and no person is bound to obey it. It is as inoperable as though it never even existed. So when the Supreme Court created a ruling and erroneously called it law, that would be an unconstitutional law. Therefore, it's unconstitutional from the moment it was created. It is inoperable as though it never even existed. That's the way it works. So because that ruling, Hurtado versus California, fundamentally changed the Constitution of the United States, altered it in other than lawful manner, then in 1887, every single court in the country was told, you don't have to have an indictment by a grand jury. So then states went out and they created their inferior provisions of their constitutions and said, we're not going to have an indictment by a grand jury. such as State of Washington, Article 1, Section 26, where it says no grand jury shall be drawn in Summit Indian County, or such as Article 2, Section 17 of the Oklahoma State Constitution, where it says the prosecuting attorney can charge by information or indictment by their discretion. Both of those are unconstitutional because they relied upon a judge-made ruling that was erroneously called law to create. You know, the states do not have the authority to be able to disregard the provisions of the Constitution. They had no authority to rely upon the Supreme Court's ruling because constitutional law 171 states that state courts and federal courts are equally obligated to guard and enforce every right secured by the Constitution. Just because you're told you can do something doesn't give you the right to do it. State of Washington, state of Oklahoma, state of Georgia, state of Pennsylvania, state of Connecticut. You know, you guys are acting in direct willful defiance of the laws of the United States and, you know, the limitations that have been placed upon you. And so when you do that, and then you go out and you start enforcing that law, well, every single time that you create a contract relying upon your inferior state law that relied upon that judge-made ruling from the Supreme Court to create, all those contracts are all unconstitutional because they derive from an unconstitutional law. So we're not attacking the individual judgments. We don't have to. All we got to do is just go to the state or to the Supreme Court, point out the fact that this is unconstitutional, and you know they're going to push back on this. We know it, but there's no denying what we're saying here. Every one of you have been out. You guys have all confirmed that what I'm saying is true. So the Constitution of the United States, Clause 1 of Amendment 5 says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. There's two crimes identified there. One is a capital crime. That's any crime that results in a death. We all know what that is. That's easy. But an infamous crime is any crime punishable by more than 1 year imprisonment in a penitentiary. Right? Now that's Title 18, subsection 4083. Any crime punishable by more than 1 year imprisonment in a penitentiary. Now, United States Supreme Court came out in a case called United States versus Coachman, and they said that it's not the amount of time that you get sentenced to, but the amount of time you can be sentenced to. Because the Constitution says you can't be held to answer for a capital or infamous crime unless on presentment or indictment of a grand jury. That means that it's the crime and the punishment that can accompany that crime that creates the infamous nature. Just because you are given 6 months doesn't mean that it wasn't infamous, because you can't be held to answer for a crime that would be punishable by more than 1 imprisonment in penitentiary. So if you were arrested and held to answer for a crime that would come with a punishment of greater than 1 year, and without an indictment by a grand jury, or if you were present in the grand jury to confront the accusations against you, then what happened was you were unconstitutionally arrested. That arrest was in violation of the Constitution. And anytime that you have an unconstitutional arrest, that cannot ever produce a constitutional outcome. You can't have an unconstitutional act resulting in constitution. That is a maxim of law. Any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation. Anytime government commits a crime in the pursuance of an outcome, that outcome is always and forever going to be unconstitutional. So how we deal with this, once again, is all we got to do is go to Supreme Court. Supreme Court, you guys broke the law. Your predecessors were traitors. They created something that they had no authority to create. They amended the Constitution in other than lawful manner, which is an act of sedition done by traitors to the nation. And what they produced was unconstitutional. And when they introduced fraud into the system by directing all the states and all the courts to, within their purview, to rely upon their erroneous ruling that was called law improperly, then that fraud that was introduced, we all know is fatal to any judgment. It vitiates any judgment. So if the judgment or if the fraud was introduced, then in order for any judgment to be valid from that moment forward, the fraud must be removed. You guys read Black's Law. It'll tell you exactly what you got to do with fraud. Nothing that any court can do can be lawful or valid because the fraud is there. Until the fraud is removed, nothing that any court does is lawful. And so that's where we're at right now. As long as the highest court in the land ignores this and refuses to address the criminal and traitors acts that their predecessors did in 1833 and 1887, then nothing that any court does is going to be constitutional, because everything the court does drives upon the highest court in the land's direction to act in a fraudulent, unconstitutional manner. So all of those judgments every judgment that any court is doing is going to be unconstitutional because these courts all must do what the Supreme Court says. And when the Supreme Court comes out with the edict that directs all of them that they don't have to follow the procedures in the adjudication of a crime, and those procedures start with the very first step, and they don't do it, or they were told not to do it, then again, that is fraud. It is the highest court in the land directing all the lower courts in the land that they don't have to follow the law, telling them that all they can break the law. And that would be an emolument violation. You can never, ever, ever create a law or a ruling, whatever you want to call it. You can never create that directs people to break the law, because the inferior law cannot break the superior law. So we've got millions of judgments right now that are absolutely 100% void on their face by an enumerated constitutional right that we can all open up the Constitution, we can all read for ourselves, we can all see that this is the truth. Where is the indictment by a grand jury for the 700,000 people currently imprisoned here in America that by states that don't conduct a grand jury? Why weren't the other, 1.7 million, why weren't they present in the grand jury to confront the accusations against them? These are valid questions, you guys. Because what you got to remember here is that the purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor. So the purpose of the grand jury is to protect the accused from a prosecutor. And yet the prosecutor makes a decision that he's going to keep the accused from being present in the proceeding that is there to protect him from the prosecutor. That proceeding is there to protect him from that prosecutor, and yet he's being denied the right to be present because that prosecutor has conspired by and between himself and the judge and the accuser to deprive him of his right to be present to confront those hearsay accusations that are against him. Is absolutely 100%, without a doubt, unconstitutional and illegal. It's a crime. It's an abuse of process, and it's violating the very basic functions and intent of that law, of that proceeding. You were supposed to be present. And what's interesting for you guys is that if you were to go and read the Hurtado versus California ruling, which is the very ruling that we believe denies us the right to be able to be present from the Supreme Court, if you go out and read it, you guys, what it says is it goes through the exact process that a grand jury has. Because what the court was doing was they were saying, okay, this is what a grand jury is. That's what it does. This is what information is or does. And it's pretty much the same thing, right? The only difference is a judge makes a determination here and a jury of your peers make a decision here. Well, once again, that's not the same, because that is not a neutral, unbiased decision maker being the judge, because he has a conflict of interest. He works for the plaintiff, as does the prosecutor. I mean, it's not rocket science to see what's going on here. But what they did was they were comparing the two. They said, well, this is what a grand jury does. Look, they're doing the same thing in California. It's okay, right? We can charge by information. And when they went through and talked about all the things that a grand jury does, they specifically say that the accused is present, has the right to counsel, and can call and cross-examine witnesses, because the accused was always supposed to be present during the presentment of the hearsay evidence that was against them. Some people have contacted me the last couple of days, and they've mentioned that they've never seen their grand jury indictment, and that they've been denied seeing it, or that the state has said that they don't have it and don't have a copy of it, or whatever it might be. You guys, not only were you supposed to be present in the grand jury, but how can you prepare a robust legal argument against a case that you don't know what the accusations are? Absolutely, you were supposed to have a copy of those grand jury proceeding minutes and record. You can't prepare a case against whatever accusations you have if you don't know what the accusations were. You guys, the wool's been pulled over us, over our eyes, guys. We've been duped by these assholes that call themselves attorneys and prosecutors. They all know the process. They all know what's fair and just. And yet they're denying you guys your right to be able to prepare a robust legal argument because they have a desire to simply push you through the system as quickly as possible through a plea bargain. And they can only get a plea bargain if they have a number of charges that they can stack and threaten you with 30 years of prison unless you accept this year today, over here. It's unconstitutional, guys. So with regard to the indictment issue, that's simple. That's the low-hanging fruit of what we're trying to do here. And when you say 700,000 people currently imprisoned on direct facial constitutional violations, that's a pretty big deal, right? That's a pretty big deal. That's a lot of people that are suffering that we don't even know if they're guilty or not, because we had a prosecutor who was overzealous, who simply took one side of a story and then said this is the truth, presented it as an affidavit to their coworker, the judge, and said, you know what, let's fry this guy. Let's hem him up so we can force him into involuntary servitude, so we can gain, products and money and revenue from his work and labor. And then we're going to tell all the people out here that he's nothing but a piece of shit criminal and that he deserves to be in a prison. It's not right, guys. None of it's right. So that's the low-hanging fruit. 700,000 people on direct facial constitutional violations. That's easy. Then we get into the 2.9 million people that have been denied the right to be present, because remember, guys, 99% of the grand juries, the accused is not present because the prosecutor has conspired by and between the judge and the accuser to deny him the right to be present. And by that criminal act, that indictment is created, and as a result, that indictment is also unlawful. There is no indictment. If you are present in the grand jury, a crime was committed in order to obtain that indictment, and therefore there is no indictment, because you can't commit a criminal act in order to secure an indictment and then have a constitutional outcome. That's fraud as well. When you have an abusive process, you deny the accused right to be present to benefit from the proceeding that is there for his protection by an overzealous prosecutor. You have gone against the very means and manner in which that proceeding was supposed to be conducted, and therefore what you produced, prosecutor, attorney general, is absolutely nothing at all, and therefore all these people sitting in prison, they're there on nothing. There's nothing keeping them there, which is one of the things that I talked about earlier on the drive over here from West Virginia. That guys, when you think about it, I have standing behind me 2.9 million people that had rights that were guaranteed to them by their birthright, that were supposed to be preserved and protected by the very people that put them there. And they're all people. They're not criminals, because there is no conviction that exists holding them there, because the government didn't follow the rules. And when you don't follow the rules, you produce a void judgment. And as a void judgment is not valid. It's as though it never existed, because it's void. So I got 2.9 million people standing behind me that have rights, and that are being illegally and unconstitutionally imprisoned right now, and then being held there under duress by about a couple thousand officers with guns. And they're being forced into involuntary servitude so that they can work for-profit companies for the direct benefit of the state. But standing in front of me is the Supreme Court of the United States, who in 1833 committed some treasonous acts and produced a seditious law that all of these people behind me are now sitting in prison believing that they're lawfully held there, but they're not. So the Supreme Court of the United States is a criminal. They're all criminals. And until they step up and correct the despicable acts of their predecessors and admit what's been done, they're all part of it. Whether they know it or not, willfully or negligently, they are absolutely responsible for the despicable acts of their predecessors. They're responsible for making sure that the Constitution is followed. They're not to follow the flawed decision of the justice that came before them or the slave owner that came before them. They're supposed to enforce the Constitution. As long as they continue to ignore this, well, they're just storing up their own sins right now, because there's only going to be a certain period of time that the people are going to continue to put up with this. And I think that time is probably rapidly coming to a close, because I've talked to a lot of you, and I know how pissed off you are. You know, I know a lot of you want to take action against them, and you know what? You guys are absolutely 100% lawfully under the authority of law to be able to do that. I don't think that's the correct route we want to go. I think that's going to be pretty messy. But I'm just one constituent of 330 million people, and I would agree that if that's what's necessary, that's what's, and we're lawfully able to do that. Our laws permit that. Because just as God said, if you eat the fruit of that tree, you will most certainly die. Our public officials should know from Scripture that when you eat the fruit of treason, the punishment is death. And we are justified in such acts, as prescribed by law. This isn't a threat, it's simply law. We're simply saying what can happen. So standing behind me are 2.9 million people. Standing in front of me is one criminal, and behind them are 40,000 criminals. Because there's 40,000 judges across this country, and every single one of them is a fucking criminal right now. Every one of them. Multiple crimes. Probably thousands of crimes, especially when you start to talk about the deprivation of rights and the color of law that occur every single time a person comes in front of that judge. And they're responsible for that crime. Whether they do it on purpose or on accident is irrelevant, because they had a duty to do what the Constitution said. They had an obligation, and they didn't do it. And by breach of the obligation, they have already implicitly invited punishment in the form of perjury should they fail to fulfill that promise. I'll answer your question in 1 second here, okay? Should they be held responsible? I don't know. Should they? I guess that's a question. I would say that they should be held accountable, because the reason why crime exists here in America is because our leaders are criminals, right? They're creating the crime. They're creating the criminal environment, right? When we have our own government going to Afghanistan and getting, drugs so they come back here so that they can drug up to people through Oxycontin, right? And then when the prescriptions run out, now their bodies are addicted to something, and they're going to go out and they're going to find, and our government's more than happy to provide all that to them, because A, they're going to create that criminal environment so that they can have the people come in and commit crimes within the environment that they created, so that they can send them off to prison and say, who's going to stick up for a drug addict? Or they're going to create a criminal environment by saying it's perfectly fine to have images of sexual deviance all spread out all over, and look but don't touch, and then have people come into that environment with predisposition to sexual deviance, knowing that it's going to produce sexual deviance over time, and thus they're going to send them off to prison, because who's going to stick up for a sex offender, right? I'm not saying that any of this is justified. I'm not saying that the drug addict has right. I'm not saying. What I'm saying is that if they didn't want crime, they could remove the environment by making good moral decisions and leading the country in a good moral direction, not being piece of shit criminals that are going to lead us in an unlawful direction by producing crimes and criminal environments so that they can profit off their illegal acts. So the question you have is, should they be held accountable? I don't know. That's up to people in the United States. But I'm going to say that in my thinking, I think they should. So you can answer that question however you want, but I guarantee you that of the people that are on here, the 100 or so people, I bet you 99 of them, minus you, agree that they absolutely should be held accountable. But, we're going to see here. We're going to see here very, very soon. All right? So let's answer some questions. Someone asked about a hung jury. He said that today he went into a jury trial, and it was 11-1. 11 not guilty, 1 would not switch their vote from guilty, and as a result, he had a hung jury. And he's wondering if they really can bring back another jury and take him through another trial. The answer is yes, absolutely they can. But typically, when you get an 11-1 in favor of not guilty, that prosecutor is probably not going to re-prosecute. Because unfortunately, these prosecutors, they rely upon their win rate, right? Because they boast about that when they go out for a re-election and whatever else. They don't want to have a bad win rate because that looks bad on them, they say. So that prosecutor is going to weigh the risk. And they're going to say, you know what? I didn't have enough evidence. I got an 11-1. And more than likely, they're not going to bring another trial against you. They're going to dismiss with prejudice, and you're going to be able to move on and just stay out of trouble after this. But yeah, they can. I mean, if they get a hung jury, they can absolutely come back and try you again. But it's going to rely upon that prosecutor to make a decision. And if they are that weak that they had an 11-1, more than likely you're in the clear. You're good. All right. So here's another one. Someone took my child and adopted her out without your knowledge. How can you address that? That's a tough one, you guys. But check this out, right? Someone was talking to me about this yesterday. We were talking about TPRs. And they said that, once there's a TPR in place, a termination of parental rights, once the court has made the decision, TPR, there's nothing that can be done. And I'm going to say that's not true at all, because that TPR occurred as a result of a judicial decision, right? And if that judicial decision derives from a judge that does not have lawful authority to be able to make that judicial decision because he lacks jurisdiction, then that judgment, that action is absolutely unlawful because it derives from a judge that had no authority to make that decision. So, what we're doing is we're going back to the beginning. We're going back to the point in which your freedoms and your liberties were taken from you. So, for instance, if you were arrested based upon an act that was unlawful and unconstitutional because they didn't have the proper documentation in place, then just because you have a judgment or a conviction today and you're in prison doesn't make that judgment valid. It makes it void, because that judgment came months after the unconstitutional act or unconstitutional arrest occurred. So the same thing here. If CPS doesn't have the authority to be able to take your child, because in 1984, the Supreme Court of the United States came out and said that there is a fundamental right to have an intimate relationship with your child without governmental interference, that is protected by the First Amendment, fundamental, then that means that the judge can't take it, because no judge can use their discretion abusively to abridge a fundamental constitutional right. Fundamental rights cannot be taken by a state, because when a state enacts its own law that says that that judge can take away that child and interfere with that relationship, even though the Constitution protects it, incorporated by the Supreme Court, by Roberts versus United States in 1984, then that law that the state created, directing their judge, giving the judge permission to be able to abridge the fundamental right of intimate association with your child, it's unlawful, right? Because it's directing the judge to abridge the obligation that they have of preserving your relationship with your child. That's the judge's obligation. That's what the law says, Constitution. So when they rely upon a state law that permits them to go against it or abridge or take away what is protected fundamental by the Constitution of the United States, it's their job, their duty, to make sure that they don't do that. A judge cannot rely upon any pure law to take away something that's guaranteed or protected by the Constitution. So when they did do this, regardless of why they did this, it was still unconstitutional, because the judge didn't have authority to do it. And because it was unconstitutional, then that means that the TPR was unconstitutional, because the TPR derived from the unconstitutional act the judge made when he took away your child and interfered with your right to have an intimate relationship with your child. So I know that this is difficult to grasp, right? That how could all of these contracts be void? Or how can we make them all go away? How are you guys going to... I don't know how that's going to work, right? I don't know. I mean, in the end, I can tell you how it's supposed to work. They must restore your liberties back to the point of the interruption. So if you were arrested, they must set you free, right? If your child was taken, they must return your child, because that was the moment that they broke the law and did something they were not able to do. So if they did adopt your child out through TPR, that adoption is not lawful, because it derives from an unlawful or unconstitutional act. So this is going to be, a very difficult thing to do. And I know that it seems like, well, this is probably way too big, but you know what? We can't say it's way too big. Not us, not the people. Because we, the people, didn't do this. We didn't make these decisions. What we did do was we created the obligations that government were to adhere to, and they didn't do it. So I don't care how big this is. I don't care how long they've done it. I don't care how many times it's been done. They caused this. It's their fault. They can figure out how the fuck to fix it. And we're not going to accept anything less than the restoration of the rights that you took from us without lawful authority, without our permission, without our consent. So, yeah, we could go back to I've got the birth certificates here with SESCB. It's something I was hoping to talk about here. But I'm just saying, you guys, this isn't about size. This is about what they were obligated to do, and they didn't do it, right? This is about what we told them to do. This is about the Constitution of the United States, the very document laws that created their office, granted them their authority, and they chose to exceed it against the will of the people. And we, the people, did not give consent to do that. And they can't do anything without our consent. Our consent derives from that Constitution. Just as our founding father, George Washington, said in his farewell address, that the very right and duty of the people to establish government presupposes the duty of every individual to obey the established government. We must obey the government as long as they're operating within the parameters of the Constitution we put in place, contract we put in place with them. When they choose to bridge those obligations and thus exceed their authority, we no longer have the obligation of obeying that established government. In fact, we have a duty and obligation, according to George Washington, to step up and mitigate that. Because if we have the right to be free, then that means we have an absolute obligation to defend that freedom. So if we don't step up against tyrants, then we are actually disobeying God, which interestingly was actually going to be our country's motto before it became E pluribus unum. It was proposed to be obedience to tyranny is disobedience to God. If we obey these tyrants and we do whatever they want, we're disobeying God, because it's our obligation to defend that which God gave to us. So we have a duty and obligation given by God to defend the freedom which God has given us, and that so many people have died in obtaining. So every single individual, and the very right and duty of us to establish government, presupposes the duty of every individual to obey that established government. Okay? So to answer your question, how do you address it? Well, let me finish doing my work here, right? Because the first step is we have to get the court to acknowledge the fact that they've broken the law. And right now today, as you all know, they are ignoring it. And as long as they continue to ignore it and continue to do it, well, it's a whole different ballgame, guys, because they've been made aware. They've been notified of the crimes they're committing, and they've chosen to continue to do it. Continue to do it. And as long as they're going to continue to do it, now they're knowingly and willingly engaging in such criminal behavior. And that's a whole different ballgame from them saying, oh, we didn't know, or we were led astray. No, now you're fucking traitors, and now you're going to hang. So, you know, if they want to fix this, the very first step is they need to start doing the right thing, right? Fixing it is not ignoring it, right? As I've said before, you know, the people of the United States, I think that we're pretty reasonable people. I think that we would understand and that we could work together heading down a more prosperous path. But we're not docile, and we're not weak, and we're not going to put up with it for that long. When we become aware that our government is outright, blatantly in our face, taking away the very freedoms that we have through an abuse of power in violation of the one thing that limits them and preserves our, that's going to be something that all of the American people are not going to be all right with. They're not going to support the judges on this when they find out what's actually happening. That judiciary is not what we think it is. For 243 years, they have been refusing to recognize and enforce the body laws governing the nation, the very document and laws that their institution was created to preserve, protect, and defend. In their entire history, they have never, ever, ever defended it. They've been undermining it so that they can create conflict, and conflict create crime, and crime create criminal, and criminals make them and their institution a lot of money. They are the source of the crime. They are what's causing it. If the Constitution got its way, there would be peace and harmony, because the Constitution bolsters respect among each person because of the equal application laws. The Constitution would bring harmony and peace amongst this nation. It would bring peace amongst all of these 50 regional governments. But they've been undermining the Union. They've been undermining the Constitution because they're anti-Constitution. Because if it got their way, they would all be out of a job. Because the Constitution has declared everybody to be free, and they're in the business of removing such freedom. So they're not what we think that they are. All right, so there's nothing that we can really do right now. There's not much. I mean, I think that there might be some people that might have a win here and there, but across the board, if we started attacking these judgments or these actions one at a time, we're going to spend the next 150 years doing nothing but attacking just the ones that exist right now, and they're continuing exponentially. So we can't really win all these battles out at the edge, you know. Our win rate is not all that good out here at the edge. Our appeal rate is not all that good out here at the edge. That's why I keep saying to us that we've got to come together, you guys. We got to come together under one single issue that affects the majority of people. And so that's why I'm doing the indictment issue, because everyone got arrested. everyone in the system got arrested. And that arrest derives from an unlawful, unconstitutional act where the state has exceeded the power authority statutorily conferred upon it by the Constitution. And they did it in two ways. First off, if you were arrested for a felony, you were held over for a capital or innocent crime without an indictment by a grand jury. There's no denying that. That arrest is unconstitutional. Every single one of you can all come together and say, why was I arrested without lawful authority? We don't got to talk about anything after that, because the moment we identify a crime that was committed by government, everything after that crime is unconstitutional. It's all tainted by the illegality of the way in which it is obtained. So if we all come together, 10 million people, and say, hey, why was I arrested without lawful authority? Now we've got attention on an issue. Now we've got magnification on one issue. Now we've got power on one issue. And they won't be able to stop us being able to address this. Guys, here in America, it only takes 3% of the population and you can change anything. 3%. 3% of the voting age is roughly 3 million people, and yet we have 10 million people currently in the system pre and post conviction. Right? We have 70 million people that have been charged with or convicted of a crime by this system. All 70 million of them can talk about the arrest. It only takes 3% to change anything, guys. We have the numbers. The numbers are there. If we come together on one single issue, point at it, they won't be able to shut it up. When the people of the United States are presented with this issue, why does the Constitution require something and the states didn't do it? There isn't a single person here in America, above second grade that doesn't understand that's the supreme law of the land. Every state must do it. In fact, we could go onto the news right now and we could look at every single public official, every single senator, every single congressman that within the last 2 years has said, oh, that Constitution is the supreme law of the land. Got to follow it. What are they going to say about this one? You got to follow everything but this, right? But this, and not only that, you guys, but it makes so much sense. The purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor. So then the prosecutor denies the accused the right to be present to confront the hearsay evidence that's against him because the prosecutor's client was granted the permission to present. Guys, it doesn't even make sense. When we present this issue to the people, we will win without even a fight. They won't even come in to rebut it, guys, because the prosecutor, being overzealous, has chosen to abridge their obligations of ensuring fair and equal application of laws and permitting the accused to be present in the very proceeding that is for their protection and benefit from an overzealous prosecutor. I mean, come on. So this is going without argument. This is going without rebuttal. There's no denying the crimes that are being committed by government and the abridgment of the constitutional obligations that they have, thus resulting in the fundamental constitutional rights that are being deprived of 2.9 million people sitting in an institution where they're forced into involuntary servitude so that they can work for the direct benefit of the state, who is also employed the prosecutor and the judge. Once we understand the dynamics of what's happening, there's nobody that's not going to be behind this. Now, whether or not, what we do with all the people, I can't say on that, you guys. I can't. But what I can say is that the way that it works is the moment that an unconstitutional law is determined to have been unconstitutional, it must be removed, and the correct constitutional provision must be put in its place. This is a process known as preemption. And once the new constitutional provision is put into place, the rightful one, then you have to let the dust settle where it may. And where the dust is going to settle on this one is every single one of these convictions, every one of these contracts that were created by the states through an unconstitutional provision that was just removed, and now it says you got to have it indicted by a grand jury, you're going to be able to say all these people, 700,000 initially, none of them had a grand jury indictment, you're going to be able to say their judgments are void, wholly without force or effect on parties involved in dispute. And guess what? The moment that a constitutional violation reverses a judgment through voiding, that government is always and forever barred from ever being able to prosecute for those crimes ever again under the double jeopardy clause. So whatever you guys are in prison for, whatever you guys allegedly did, you're going to be given an opportunity to return to the point in which government took your liberties from you without lawful authority, to the point of your arrest. Now, there's no magic time machine that exists, guys. You know, we're not going to be able to go back to, the period of time that you lost. But what we can do is we can make things right. Right? That's the least that they can do. Because these people changed the trajectory of your life when they broke the law. You see, their obligation was to find you guilty beyond reasonable doubt. Their obligation was to investigate and to make sure that innocence doesn't suffer. And instead, they just looked at you and said, oh, I think this guy's a criminal. So I'm going to bring him into this jail here, and I'm going to deprive him of all of these liberties, and I'm going to threaten and intimidate him. I'm not going to feed him enough. I'm going to deprive him of his communication with his family, and I'm going to do all this so he's more malleable to accepting my offer when I come and say, if you don't plead guilty, I'm going to send you to prison for 20 years. You say, I don't want to go to prison for 20 years. I'll plead guilty. Even though I'm not. So when you deal with information is an affidavit, right? And an affidavit in common law is truth. And in fact, this affidavit is being presented to the court as truth. But the problem is that this affidavit is being prepared by a law enforcement officer who obtained the information from your accuser. And that law enforcement officer then took that information, reduced it to writing in the form of this affidavit, and then submitted it to the court using his oath, saying, I swear under my oath that this information is truthful, factual, and correct. But that officer wasn't a witness to that. How in the fuck is he submitting that as though it's truth under his oath? Because the Fourth Amendment says no warrant shall be issued but upon probable cause, supported by oath or affirmation. We have a Fourth Amendment violation every single time this officer submits that affidavit, because that officer cannot submit that as truth because he wasn't a witness to it. Therefore, the warrant that's being issued is not upon probable cause supported by oath or affirmation, because the oath must be taken by the person submitting the information. That affidavit needs to be written by them, presented by them, not by the officer. The officer has no authority to do that. So when this happens, at common law, the affidavit is considered truth, right? And any unrebutted accusation is, in fact, truth. So when they submit this information to the judge and say, Judge, I'd like you to hold this person over, when that judge doesn't have you present to be able to confront the hearsay information that's against you, then what they're doing is they're making it so you can't rebut it. They're making it so that is absolutely truth, right? And they're doing it intentionally by preventing you from being present to rebut the affidavit. And any unrebutted affidavit is truth. So they're doing these things intentionally. But then what happens is that judge says, yep, there's plenty of probable cause. I think it's all good. I don't give a fuck about what he has to say because, officer, you brought this information to me and it's truthful, factual, and correct, right? So then that judge orders your arrest without lawful authority. Because remember, Constitution says no person shall be held to answer for a capital or otherwise serious crime unless a presentment or indictment of a grand jury. Problem is that judge makes the decision to hold you over. So it's the judge that commits the crime. It's the judge that establishes the conspiracy. It's the judge that should not have made that decision to hold you over, because his duty and responsibility is to make sure that the law is administered properly, and that means all the paperwork is properly in place. So when the prosecutor does bring the charging instrument, or the officer brings it, it's up to that judge to make sure that the proper documentation is there. And if it's not, that judge committed the crime and he established a conspiracy by and between himself and that prosecuting attorney and law enforcement officer and anyone else that's involved in the fucking arrest. So then they order your arrest, and you go out and they arrest you and they bring you in. And now guess what, man? You guys are being deprived of liberties that were supposed to be protected. You had the right to be able to be free until proven guilty. You had the right to use your property and earn your wages and take care of your family and love your kids. You had the right to do all those things protected by the Constitution. And now you're being deprived of them simply by virtue of the fact that someone accused you of committing crime that you've never had the opportunity to rebut. But you're being deprived of all those rights. Now, this kind of brings me to the next question here, and that is that you guys, investigative detainments under our Constitution was always unconstitutional until around 2002, right after September 11th, right? Because what happened in 2002 was they created the Patriot Act. And it was the Patriot Act that allowed them to start doing investigative detainments. And investigative detainment is they're detaining you while they investigate. Right? They're arresting you and holding you over, without being found guilty of anything. You're not supposed to be held in a jail, right? These questions I have here, I've got someone that's contacted me that said that her son has been in jail for 4 years. 4 years down in Georgia. 4 years without ever being convicted of anything. 4 years, right? I got another lady that called me today that we talked. Her son's been in jail for 2 years. He's never been charged with anything. What the fuck is going on here, right? Held in custody, 4 years in custody, in a jail. I'm going to dig into this. I'm going to figure this out. I mean, first off, it's absolutely unconstitutional. But I know that it started, in 2002. I know that it derives from the Patriot Act. I know that it was further exacerbated by COVID, but that doesn't make it right. Just because we do it doesn't make it right. That's not a speedy trial. That's not a speedy public trial. That is absolutely 100%, without a doubt, unconstitutional. And I want to figure out why they think that they can do it. And I know that it has something to do with COVID, because we saw, these extended periods of time there. But COVID doesn't give permission to change laws. Emergency Powers Act doesn't give the permission to suspend laws. The Constitution is there to restrain and limit government, and government has no authority whatsoever to lift the restrainment that they have at their discretion. So I don't have an answer yet on these, but there is a speedy trial and a public trial. And they have to still adhere to that. It doesn't matter if we have COVID. It doesn't matter if there's, Emergency Powers Act, which, by the way, is unconstitutional. It doesn't matter whether, we sign a Patriot Act, because any act or law that's contrary to the Constitution is unconstitutional. And it's already been determined by the Supreme Court. It's already been incorporated that you have the right to a speedy and public trial with a neutral and biased decision maker, which is not a judge or prosecutor threatening you. So you have that right, because they have the duty to do it. And clearly, in this case, these two, they're not doing it. These people should not be there for 90 days, and they should never, ever, ever be in an investigative detainment. It was always unconstitutional in violation of due process. But what happens then is that you guys are presumed to be guilty based upon the mere fact of being charged with the crime. They charge you with the crime, and now they're going to treat you as though you're guilty. So they go out and they arrest you. Take you to jail. They deprive you of all your rights, the right to take care of yourself, your family, use your property, all of which is protected by the Constitution. And they believe that they can do that because they think that you're guilty, because they got information from the officer. This is what's known as an irrebuttable presumption of guilt. It's an irrebuttable presumption of guilt because you guys never had the opportunity to rebut that accusation against you, right? And again, any unrebutted accusation is truth. Well, the reason why you weren't able to do it was because they denied you your right to come in and be there, right? And so what happens now is that there's a shift in the burden of proof. Normally, the prosecutor has to prove that you're guilty beyond a reasonable doubt. That's what we all know. Guilt beyond a reasonable doubt. Prosecutor has a burden of proof of proving that you are guilty beyond a reasonable doubt. But in an irrebuttable presumption of guilt, the burden of proof shifts. And now the defendant has to go out and collect evidence to prove that they're innocent. And this particular breakdown of due process, this shifting of the burden of proof, occurs, according to Blackstone, anytime that the system focuses on speed deficiency as opposed to procedures and processes. You see, the system was supposed to rely upon the procedures of the Constitution in order to protect the liberties of the people by limiting the powers of government. That's the intended purpose of the Constitution. But there is a breakdown of the Constitution when the system says, how many people can we push through? And then they use the excuse that if they don't have plea bargains, it would clog up the system. If they didn't have plea bargains, these people would get away. That's not true, government. What is true is that if you have to go through a trial by jury, right, and you only have a limited number of people that you can take through trial by jury, then that means that you're going to have to prioritize, government, prioritize, right? And that means that you're going to have to come up with alternative solutions to societal problems, because is that not what government's purpose was? So instead of saying, I'm going to lock you up because I don't want to have to do anything, that's not coming up with solutions to societal problems. That's not being a good government, right? That's not doing your job, politicians, because that's not what you, no, you would not clog up the system. What you would do is you would have to come up with solutions to society. You have to do your job. So don't give us the bullshit that it would clog up system or that you have to do it this way, because that's just justifying your unlawful acts. That's just permitting your criminal conduct to continue by justifying it in some bullshit way. No, you would fix the fucking problem. You wouldn't proliferate it. So there are solutions that we could come up with to fix these societal problems. There, we could take care of the people. We could help them get houses and jobs. We could, not have scarcity exist because you want to fucking make money. That's not how it works. So, we just want to make sure that we all understand that just because they say that they have to do it, because look at all these people they have to fucking prosecute. No, you don't, right? What your job is to do and follow the law that binds you to your duties. So the Constitution says what you got to do it. And you can't justify your acts otherwise. So, so Blackstone wrote about this. You guys can all read about it, right? When you have an irrebuttable presumption of guilt, what happens is the system focuses on speed and efficiency instead of established procedures and processes, and it is absolutely a breakdown due process because of the shift of the burden of proof. Now the defendant has to go out and prove that they're innocent, and the prosecutor does not have to prove that you're guilty, right? And according to not only United States constitutional law, but international human rights standards, never, ever, ever does a defendant ever have to prove that they're innocent. That would be absolutely a violation of human rights standards, not only domestically, but internationally, okay? I'll come back on that. All right, so how do you get involved, right? How do you get involved? Guys, this is pretty simple, all right? What we're doing is we have a habeas corpus. Habeas corpus is a request, judicial request for relief. What it does is you will use it anytime that you've had liberties deprived of you without due process. And in this particular case, we are challenging the validity of the detainment, which is the exact purpose of the writ habeas corpus. If you have been unlawfully detained, or if you are currently unlawfully detained, you will use a writ of habeas corpus to challenge that detainment. That's exactly what a writ habeas corpus is for, right? So if your arrest was unconstitutional, or they didn't have authority to do it, then you would use a writ of habeas corpus to challenge your detainment. And if it's determined that they didn't have lawful authority to detain you, then they must restore you to the point of such detainment. They must remove everything and give you and set you free, put you out, remove the unlawful detainment. It is a judicial relief, which has a very, very limited period of time. It's a very quick process. It's not a typical appeal. It would take multiple years. This is a judicial relief. You are going to the judges and you're saying to them, I was unlawfully imprisoned, I was deprived of due process, and as a result, please restore my liberty to the point in which it was interrupted. And they have to do it. Now, one thing is that you can't ask for money in a habeas. We can't ask for money. All you can ask for is a restoration of the liberty that was deprived of you, right? Restore your liberties. Set you free, release you from prison. And they would have to do that. But now, I'll answer that in one moment here, Al Marie. So now, what we're asking for is simply, Supreme Court of the United States, we want these people free. Return them to the point in which the constitutional violation occurred, remove their unlawful imprisonment. That court then would have to direct the states to release them that were unlawfully and constitutionally imprisoned, right? In violation of due process. There's no denying that you guys were unlawfully arrested. Your detainment was unconstitutional because it derives from an unconstitutional act when they failed to have the proper documentation in place in accordance with the Constitution. That's what we're doing. But the way that a writ habeas corpus works is that you can't have a class action. If you establish a procedural situation that affects the class. So what's a procedural situation? That is documenting and identifying the way in which they do it that affects multiple people. So for instance, if the United States Supreme Court enacted a ruling that was called a law and then changed the Constitution, and then they directed all the states that they don't have to have an indictment by grand jury. And so then the states went out, created their own laws, and then went out and arrested a whole bunch of people with a law that says you don't have to follow the Constitution, which is unconstitutional. Then that means that arrest is unconstitutional. It is in violation of your due process. So there's no denying that. And so then we would say to those justices, restore original liberty. Once we identify that procedural process, which is what I've done in the affidavits. That's why the affidavits are exactly the same no matter what state you're in. And it's the same information. That's why I used a person portraying themselves as a judicial officer, a person portraying themselves as a prosecuting attorney, because we don't know their name necessarily. A lot of people don't, but we don't need to know it because that would come from an investigation. What we do know is that the material fact is that someone pretending to be a prosecuting attorney did deprive you of a right when they charged you by information, not by indictment, in violation of the Constitution of the United States. Deprivation of rights under color of law. They have made an arrest without lawful authority because they didn't follow the rules. Then the next procedure is that a judicial officer or a person playing a judicial officer did conspire with a person playing a prosecuting attorney and a person playing as a law enforcement officer when they held you to answer for a capital or rampant crime without indictment by a grand jury consistent with Clause 1 of Amendment 5. There's the conspiracy. So by that procedural situation, that's the same for everyone, because every one of these states have said, oh, well, we can charge by information, or we can use our discretion abusively to bridge the law, right? But regardless, the procedure remains the same. And under Rule 23 of USCIS Rules of Civil Procedure, you can create a class action habeas, which is what we've done. We've already petitioned and asked for it. We've already done the first state, Washington, with more than 4,000 people petitioning across that state. And we're about to start the second next week. And we're going to continue. So I've got habeases, the exact same habeas corpus with the different state law, the different state provisions that direct the state agents to act unconstitutionally. It's the same thing, written the same way, same words, except for Oklahoma has a different provision in the Constitution. Arkansas has a different provision. All we got to do is just switch those out from one habeas to the next. And now we can file a habeas corpus on behalf of anybody that's being held in any one of these state prisons. And we're going to make that the next attack next week. So, when we come in and we say, all right, here's 500 people we know were charged by felony information in the state of Arkansas. Well, all I need is their name, and I can go and file on their behalf, because anyone can file on behalf of someone, a habeas corpus on behalf of someone they believe is being held in violation of their constitutional rights. That's what ACLU did down in Guantanamo Bay. That's what secured the release of all those suspected enemy terrorists, right? We're going to do the same thing, man. So next week, we're going to start bringing in the states to a whole new level. So when we go into the United States District Court on whatever day with 150 criminal affidavit or habeas corpuses that cost me $5 a piece to file, and we're going to file them for this guy. We don't have to get their permission. I don't have to get anything from them. All I have to do is know their name and what facility they're in. Right? And know that they've been held against their will in violation of their constitutional rights, thus charged by felony information, which you can get off of any one of these websites, OSBA or whoever, because all that information is public information. I can know who was charged by felony information because that information is readily available. So that's what we're going to be doing next, right? So we have a procedural situation. It's been documented. It's been identified in that affidavit. It's very specific, and every single one of these judges, prosecutors, law enforcement, they're all following the same procedure. So when we come forward as a class action habeas, any one of the petitioners will all meet at the same level. Well, I've already taken this habeas all the way through the state courts, all the way through Washington, all the way through the United States District Court and the Ninth Circuit, and I'm sitting at the Supreme Court on a jurisdictional error. That jurisdictional error has no time frame to kick it in. I can bring it in at any point in time because it's a void judgment, because the district court stated in their ruling, summarily dismissing it, that they lacked jurisdiction. And when they did, that created a jurisdictional error, and a jurisdictional error can only be addressed by the court that had jurisdiction to begin with, which in this case would be the United States Supreme Court. So at a minimum, the United States Supreme Court must address the jurisdictional error that was made by the district court, at a minimum. Now, typically what they would do is they would simply reverse or remand. They would reverse it. They would declare that, yes, it is unconstitutional. They would send it back to district court, who would then dismiss it legally and lawfully without making the same error they made before. That's what they would normally do. But we got a couple of aces up our sleeves. They're not going to be able to do that. If they do that, it's going to open up a big can of worms that they don't want to open up. All we're trying to do is get them to declare that people in the United States are guaranteed the rights, entitled to the rights that are enumerated in the Constitution. Just give the people the fucking rights that they have. Quit denying them, or quit lying to them, and just give them to them. That's all we're asking. That's it. All right? So, a habeas corpus, all petitioners meet at the same procedural. If one petitioner overcomes a procedural situation, they all do. So if I'm at the United States Supreme Court, ready to kick it in, then that means that anyone who wants to join me will join me at my level, where I'm at. They will not have to go through the state courts, because I already went through the state courts. They will be able to come and meet at the same procedural level. So because I've overcame the states and the state Supreme Court, because I've overcame the district court and the circuit court, then everyone has overcame that, and you all meet at the same level. You guys are at my level, Supreme Court. Then what happens is that if a petitioner wins and overcomes the case, they all overcome it. It's called vicarious relief, because we're all in the same situation. So if anyone wins their argument, anyone overcomes, they all overcome. And we got 2.9 million people that we're ready to bring forward. 2.9 million chances to get this right. I think we're going to get on the first one, but if the first one fails, I got a whole lot more coming. And we're going to overcome them in one of them, right? And so once one petitioner overcomes the procedural situation, every petitioner overcomes the procedural situation. So we have 4,000 people that petitioned between April 10, 2019 and September 2019 in the state of Washington. If I successfully win my argument and overcome it, which I will, then automatically, instantly, those 4,000 people will also receive their relief and release from prison, because they petitioned, because they're in the same situation. Now, that's the people that petitioned, right? That's the people that actually submit a habeas, and whether it gets denied or proved, it doesn't matter. We're just waiting for the one to overcome and win. But that doesn't mean that just because you didn't submit a habeas that you won't get it. No. Once the judgment is in place, then all you got to do is file a motion to vacate judgment for lack of personal jurisdiction citing that case, and you get the same thing, because you're part of the same procedural situation. Anybody who has been deprived of the right to be indicted by a grand jury, consistent with Clause 1, Amendment 5, will receive relief if any one of us overcome this case and win it. Everyone. So how do you join? Guys, what's most important right now is we make the court stop ignoring us. And the only way we can do that is by getting louder. You guys getting behind me. You guys supporting this. You guys pushing forward, because this will overcome your enslavement. This will overcome your restrictions. This will overcome your lack of gun rights. This will overcome your lack of voting rights. This will overcome everything that they've stolen from you without lawful authority. Because this goes back to the point that they arrested you and deprived you of your rights. You want your gun rights back? We got it right here. You want your parental rights back? We got it right here. You want your freedom back? We got it right here. You want your right to vote back? We got it right here. All we got to do is come together and talk about right here, and let me go litigate this for you. Let me go fight this battle for you. I'm prepared. But I can't do it on my own. I need you guys behind it, and that's how you guys can join. Get me a fucking affidavit for the crimes that are committed against you, and then get your ass out here and start defending this. This happened to you. We don't need to talk about anything but what they did to you, the crimes they committed against you when they took away your freedoms, your liberties without lawful authority. We don't need to talk about anything else. You don't need to talk about the evidence. You don't need to talk about the judge. You don't need to talk about the prosecutor. All of them are just there to distract you from the fact that the state couldn't do it to begin with. And that's a point that everyone can talk about. That's the whole point. We get everybody together, talk about one issue. We have massive amount of power on that issue now, and it will never be shut up. They will never be able to ignore it. But they sure the hell can today if I'm the only one that's arguing it. Right? So we want to get the attention there. How can you join? Get me a criminal affidavit, and then let's get ready to get these states joined. It's going to cost me a lot of money to reproduce these habeas corpuses, because there's about 60 pages in it total, and I got to do 100, whatever. I'm gonna need to have somebody to do it. We're gonna have to do some fundraising, but on top of that, I'm gonna need to have the money to file them, because I can't do a form of papyrus on their behalf. So if I have 100 of these I'm going to file in Oklahoma, or I have 100 of these I'm going to file in Arizona, then I'm going to need $500 just in filing fees alone, not including printing. So we're going to need to work together on that one too, you guys. I'm going to need to get this paid for, because I cannot do things that I don't have the resource to be able to do. So just be aware that that's something that we're going to need. Okay, we need. But that's the next attack that we're going to have. I'm going to start piling as many as possible on these states. And if I have 500 of these I'm filing against the state of Oklahoma, well, that's a pretty big deal. And I will definitely call a press conference and see if 500 is enough to get the press there. Because there's going to be a number that's going to be, that will bring them in. I don't know what that number is going to be yet, but, we're going to figure it out. If it's 100, awesome. Let's get 100 of these filed in every single district court. Let's call a press conference, and let's get the press there to let them know that we have 100 people that are being unconstitutionally imprisoned, and we are now today filing writs habeas corpus demanding that they get their liberties restored because the state is not following the Constitution. All right? So how many is it going to take? We're going to see. We're going to find out. So we have the intent to do that next week. The habeases are already done for a couple of states, but it's a very, very simple switch between them, right? Very simple. It's already written up. I wrote it for Washington, and now we're just simply regurgitating it and switching out the local law as opposed to Washington law. Easy. Guys, there's someone that continues to portray themselves as me, and they're messaging you, calling you, whatever, asking you for money. They use my logo, they use my videos, and they use my name. It's not me, guys. It's not me. And I think that this person is probably the biggest piece of shit that I've ever known, personally, because they have stolen a lot of money from people while committing me to do things that I can't do. That's a pretty fucked up deal, because this person clearly needs my help, or is going to need my help, and yet they're robbing the limited resources that we have to deal with this, right? They're robbing from all of you and taking away from what I need to be able to do this, and they're doing it for what? Whatever. Because anyway. They're not me, guys. If you guys get a message from someone, a call from someone, an email, whatever, and they say that they're me and asking for money, it ain't fucking me. Please don't loan them money anymore. Please, stop. The last few days I've had people actually call me, people that I know that talk to me, call me and say, didn't I just have a conversation with you? No, you didn't, man. They're texting me saying that they were just in a full-blown text conversation, and that they just gave money. So Tanawah Downing is the only TikTok account I have, only one. Tanawah Downing 1, Tanawah Downing 2 is not me. And if I'm asking you for money, or if I'm telling you that you have to pay me in order to talk to you, guys, that ain't me. I've never asked you guys to pay me a cent for the things that I do. I will do this whether it's money or not. I've told you that. I've been blatantly clear on this. God pays my time. You guys don't have to. If you want to donate, you You can donate, but you do not have to pay me for anything that I do. So please don't pay this person anymore. They're a piece of shit. So someone said that they believe that if the people weren't suppressed, crime would go down. Absolutely it would. Absolutely would. The reason why I want to answer this question is because I want to tell you guys a story about my time when I was in prison. Guys, you know that I went to prison. I went to prison for the crime of talking to my wife, who wanted to talk to me. This judge and prosecutor, they didn't like me telling them that they're breaking the law when they threaten and intimidate witnesses to plead guilty. They didn't like that. And as a result, they wanted to make an example of me. And they thought the best example would be, well, let's get him out of prison. So let's put a no contact order between him and his wife, who are married and been married for 16 years, and we're gonna put a no contact order between them because we know that they're gonna break it. And you're goddamn right, I'm gonna break it because I made a promise to my wife that I'm gonna love her and take care of her, and as long as she wants to be married to me and communicate with me, then judge, you can't tell me that I can't fulfill my obligations to God and fulfill the contract promises that I made to my wife. This is right of conscience. So it's not a crime to talk to your wife. It is a crime for a judge to create a law that directs me to break my obligations, right? No state shall create a law that shall impair the obligation of contracts. All right. So when I was there in prison, guys, prison. I know all the stories. I know what people say. I know what movies portray. But I'm going to tell you right now, I didn't see any of that shit. When I was in prison, I saw a whole bunch of people that were good. That gave me a reason to step up and do what I'm doing right now. Because that first week that I was there, when I went to church that Sunday, that first Sunday, there was less than a dozen people in that church, and it was miserable. It sucked. Like it was just miserable, sad, and less than a dozen people. But I'll tell you what, 18 months later when I left, and by the way, you guys, I stayed in prison every single day, all through my good time. I stayed there until the day that they kicked me out of there, because I need to get as many people as possible to petition to save them. I need as many people as possible on this group so I can bring this army together so I can fight this injustice. I was there for a reason. I was there to work. I wasn't there because I was in trouble. I was there because I needed to be there, because God wanted me to be there, because that's where I needed to go to complete my mission, to do my job, right? And I accepted that. So I stayed an extra 11 months. 11 months. I could have been out at home, and I stayed there because I needed to do this, right? So I stayed all the way through my good time. Till the day that they kicked me out, I stayed there. But I'll tell you, when I first got there, that first week, less than a dozen people were in that church. It was horrible, miserable. When I left 18 months later, it was standing room only. 350 people, all standing up, all hugging, clapping, smiling, and the line was still out the door, almost all the way to the minimum side. Guys, that's called hope. It's called hope. Because when Jesus came and he was doing his job, he was ministering, who was he sent to? Was he sent to the people that had a job and a house and a car and a bank account? Or was he sent to the hopeless? You see, if you want to change the world, who better to enlist in your initiative for change than those that are right to be filled with hope? You see, I had to go to the hopeless. That was the place I needed to go, because those people, they all came to believe in something. Because when you're told that you're nothing, when you're told that you're not worthy, when you're told that you're just a piece of shit, you're going to go, those people want to believe in something. They're hoping that something exists that's going to be better, right? They're praying that someone gives a fuck about them, right? And I'll tell you who does. His name's God, right? He cares a lot about them because he sent me to go and help them, right? Not because I was being punished, but because they needed help. And that hope, guys, I can tell you, personally, I've seen it. These people are not what we think that they are. They're not what the system says that they are. Because I saw them change. When I was there wasn't a fight. Well, 2 fights. They never locked the place down. People got along, right? We had the North Siders and the South Siders normally feuding gangs, right? They came to me and they said, could we use this as a means to bring peace? Guys, they were on the field together, right? Not beefing. We had the black car, they asked me to come and present to them this. Look at me, right? This doesn't happen. I personally could go anywhere in that position. I could walk out in the yard and nobody messed with me. Nobody. Because I was there for a reason. They knew it. Once you bring hope into the hopeless, they're hoping to be filled with something. The reason why they're violent, the reason why they're doing the things they do, the reason why prisons are so bad is because these people don't have any hope. Right? They don't have any. They think that this is their fate. Right? The laws are not being applied to them. They're being abused and they're being taken advantage of by the very institution that was meant to protect them and preserve their liberty and freedom. So I don't blame them for being mad. But you know what? When you filled them full of hope, everything changed. Everything. So when you say that you believe that if the people were depressed, crime would go down, I'm going to tell you, I know it will. I know it will because I saw it with my own eyes. I saw it. And when this is all said and done, I assure you that when we look at that prison and we look at that period of time from this period to here, and when we see what happened when hope was brought into that facility, I guarantee you that it is going to show, it's going to be black and white. That period of time, those people, it was summer camp for us, man. They all got along because when they realized that, hey, this might actually happen. This could happen. Like the laws are in our favor and we're not supposed to be here. When that happened, they don't want to fight anymore because they don't want to miss the opportunity. They don't want to mess it up. So I'm going to tell you that it will. The crime will go down dramatically the moment that we choose to apply the laws equally and to treat every person with respect, because that's what God demands. God didn't create anyone to be abused and trodden upon by his fellow man. And I'm telling you right now that the crime will go down. And I'm telling you right now that if we give those people a second chance, right, they know what's at stake. Every single prisoner knows what the freedom is like when it's taken. They will not go back to that life. They will not do it. And scripture even says so. There's the parable of the temple, when the Pharisee's standing there and the sinner's standing there, and the sinner, he won't even look up because he knows he's a sinner. God has made it clear. He won't even look up. But that Pharisee's over here going, at least I ain't this fucking guy. You see, the ones that are in prison, they are the ones most unlikely to return there if they're given an opportunity to never have to be back. If they're given an opportunity to have a life that's equal to everyone else, they know how much these rights cost them. Right? They know it. And they're not going to go back to that place. I promise you. I've seen it with my own eyes. And you know what? God demands it anyway. So as scary as it might be, I'm going to trust God on this one because he says it'll work, and I believe it'll work because I've seen it with my own eyes. So you're right. If we stop oppressing our people, crime will go down. Absolutely. That's why I say every day that it's that court and it's a system that is responsible for all the crime. They're the ones that do it. They create the conflict. They create the interference. They don't permit communication. And as a result, man, they're fucking causing all of this, man. All of it. So sending affidavits. Again, you guys, today, we still are having problems with these post offices, okay? They're still returning to sender. Some are getting through, but not very many. So I've chosen to not focus on affidavits right now. We're going to take it back because there's a lot of people that still need to hear what I have to say. There's a lot of people that still need to hear about how their rights are being taken. So I'm going to focus for the next little bit here on getting out and continuing to spread this message. You know, I'm heading up to Maine tomorrow, and I'm going to be in Maine, Vermont, New Hampshire to file. But while I'm there, I'm going to be hoping to meet people. town hall meetings, and have these discussions with you guys, because there's a lot of people that need to hear what I have to say. So instead of focusing on the end, what we need at the end, I'm going to focus on how do we get to that end, because there's a lot of people that need to hear about this that haven't heard about it yet. So we're going to hold on the affidavits for a little bit, right? Because everybody's still going to come back and do an affidavit, even if they, lose interest in this because it's not moving as fast as they want. Well, the whole point here is we need to get as many people aware of the situation. And when the time is right, I will make a call to the people that are aware, and we'll have that 500,000 in an instant, right? I'll be in a bus. We'll be doing the final tour, 32 press conferences at 32 state capitals over the course of 40 days, ending in Washington, D.C., where there won't be a single news station in the country that won't be there to meet me, greet me, and watch me as I walk to the Supreme Court to deliver oral arguments on behalf of people of the United States for the deprivation of rights and freedoms that have been deprived of them by this government. That's what the tour is about. That's what we're moving toward. And when that call is made, we will have that 500,000. We'll put them in the bottom of this fucking bus, and we'll drive straight up the ass to the Supreme Court, okay? Thank you guys so much. I'm going to take off. It is time to go to bed, and we're going to wait on the signatures just a little bit. We need a lot more people to be aware. Right now, it's about aware, right? So we can, and also Justin, for everybody, actually, not just Justin, but so we are, I have some people that are on board, like some new groups that are helping. They're really, really interested in helping. And I know that all of you are too. So we're going to put together the information that you need so we can get these counties served. Because I believe that that's the last step. We got to get the foundation served. So I've done all the top. I've done all the state Supreme Courts and the state Attorney Generals. I've done all the top level. And it's all ready to fall. But we got to do the foundation now. So every county, we need to serve the highest judicial officer in that county. And we need to serve the highest executive officer in that county. That's where we need your help, guys. So we're gonna get the documentation together for the affidavits, for the criminal act, the absence of the grand jury, as well as also the familial unit. And it looks like there's going to be at least 3 different versions of this familial unit, because I can't get them into one single standard procedural situation, unfortunately. Because in some cases, law enforcement wasn't included. In other cases, CPS wasn't included. But regardless, a deprivation of your right to have a relationship with your child was occurred, whether it's the judge that did it in conjunction with your former spouse, or whether it's CPS came in, or whether it's law enforcement did it without. There's a few different variations, and I'm going to have to get I'm going to have to produce the 3 of them. It looks like. So I don't know how that's going to play out when it comes time to grouping together into one single class, because there's going to be actually multiple procedural situations. But we'll work through those bugs when we get there. So those affidavits are going to be available on the website, along with the instruction sheet on how to serve, the pitfalls that you guys need to know about. We're going to put all those videos together, hopefully this weekend when we're up in Pennsylvania. We'll get it done. But regardless, that's the next step. That's how we're going to get all of you guys involved. Every one of these counties need to get served. You cannot serve for yourself, right? But you can serve for someone else. As long as you're over age 18, you're a United States person, then you can serve these criminal affidavits to the highest, the chief judge within your county, and to the elected prosecuting attorney of your county. Okay, so we're going to get that together, and we're going to start that as soon as possible. And we've got a couple websites that are pushing it, and so I'm excited to have some people on board that's going to be able to back me up a little bit here. So that's where we're at, all right? But we are going to wait on. I'm not going to push the affidavits right now, because I just think that it's still premature. There's too many people that need to know about what I'm doing. And every time I go into one of these cities, like a new place, they're like, I've never heard of you. And then why is that? I don't know, but there's a lot of people that need to hear about this. So I'm going to focus on getting that done, getting the information out, because, like with these podcasts, I've done, 10 podcasts in the last week and a half. With these podcasts, I'm not getting big numbers, but I go on there and I explain what's going on. Every single time, they're like, oh my God, how do we not know about this? Like, how did you do this? And the answer is, I don't know. But clearly, I've got 500 people that thumb up for these podcasts with 2 thumbs down. I don't give a shit about the 2 thumbs down, because I got 500 thumbs up. So that means that there's 500 people that want to hear what I have to say, 2 people that don't want to hear what I have to say. So I need to get out there and I need to find these 500 people because there's a lot of them. Because once they hear me talk for an hour, they're like, holy fuck, I want to get behind this. So we got to figure out a way to make this move a little bit quicker. But until that happens, I don't think the affidavits are the big push. Justin, save him on site, hold him there, and we will collect him. But because the post offices are not working with us, and we didn't even have that high numbers coming through, this would be very, very problematic. So I think we're going to push it back to when we actually start the tour around the country, 40 days. When we return back to Washington, D.C., that's the moment that we're docketed. Because the moment we're docketed, we know that there's going to be roughly 40 days from the day we're docketed until the day of oral arguments, and that's where the 40 days came into play. 32 press conferences, 32 state capitals over the course of 40 days, ending in Washington, D.C. So that's what we're going to do with them. There will come a point in time, we will reach that number, but right now, there's a lot more people that need to hear about it, and so let's get them to hear about it, and then once we get on the docket, once they agree to give us a case number, then at that point in time, we're hitting the bus, and we're getting around the country so we can get back to Washington, D.C. with those $500,000 criminal affidavits and present the arguments, okay? Thank you all so much. All right, guys. Please continue to like, follow, share. Go out and research yourselves. Make sure that you guys agree with everything I'm saying. Go and research yourself. What I'm saying is absolutely true, right? Every bit of it, right? And when an attorney tells you that I'm wrong, go and read the law, because the law is the truth. That attorney's a liar who's built an institution on their criminal acts and who doesn't want that institution to go away. So these attorneys are all fucking criminals. None of them know about the law because they were all trained to break the law. And as a result, their entire career is completely a fucking joke because they call themselves an expert and a doctor of the law when in all reality, they never even fucking knew the law. That doesn't make you an expert. That makes you a criminal, okay? So they are what they are. Don't buy into their bullshit. They don't know what they're talking about. And they can tell me that I don't know what I'm talking about all day long, but unfortunately, I know the law, and they don't, because they're just criminals. Criminals don't know the law, clearly. Okay, so please continue to like, follow, share. Please comment if you can. Keep us into the queue, and if you can, please get out there and donate. We need money, guys. I need money to continue to do what I'm doing, and I do this because I love all of you. I'm going to do it whether I have money or not, but you guys can make it a whole lot easier for me if you guys will please continue to donate so I can continue to move. We just traveled 1,200 miles serving those states along the way, and we got another 900 miles to get up to Maine. That costs gas, guys. Fortunately, I have someone that's letting us use their vehicle, so I'm doing this as cheap as possible, but I still cannot afford the actual tangible cost. So if you guys are willing, if you want to get behind this, if you like what I'm saying, what I'm doing, please get out there, get behind this. You can donate through Cash App. The only Cash App that I have is We Shall Be Free. That's WESHALLBEFREE. We Shall Be Free. Any other Cash App is a fucking liar and a thief. Don't donate to them. It's only We Shall Be Free, because this is the We Shall Be Free tour. So we have Cash App, Chime, Venmo, PayPal. They're all exactly the same. We Shall Be Free, all right? They're all exact same. We Shall Be Free. If you prefer to donate through the website, go to the website. You also have donate links up at the top, right next to the Get Affidavit link. Go out there, donate, please. We need the money. Every single cent that you guys give to us, it doesn't go to kids' orthodontist payments. This goes to every single day, figuring out how am I going to get over on the system? How am I going to get this finished? And there's going to come a point in time, you guys, when I'm not going to need money from you anymore. Right? There's going to come a point in time when I'm going to be able to self-finance this, and that's my hope. Right? I don't want you guys to pay any more money than you have to, but I need your help to get to that point. And once we get there, I will pay for this myself. Right? But I can't do that until we reach that point. You guys are getting me there. Please continue to do that. So please continue to like, follow, share, comment. Please donate, and together we shall be free. All right? Thank you guys. God bless. Have a great rest of your night. All right? Thank you, TikTok. Appreciate it, everybody. God bless. Have a good night, all right? Thank you, YouTube. Appreciate you guys. God bless. Have a great rest of your night, all right?